Heads up, if you hear a dog barking, I apologize ahead of time. Um, but thank you for coming. We love partnering up and being able to give these workshops. And we know that guardianship is something we get a lot of questions about. So we were very happy when we were able to team up. And yeah, that's it. So thank you guys for coming. And if you have any questions, comments, concerns, you can email me, kdavino@dsah.org. And enjoy. Hope you learn a lot.
Great. Thank you for having us here today, Kay. We really appreciate it. I'm Allison Scaber, Consolidated Planning Group. We are a holistic special needs financial planning firm, and we really custom design plans for people based off of their needs, wants, and goals, but really focused on the issues at hand of a special needs child that may or may not need care for the rest of their life. We are excited today to be here with Boyd Handley. When it comes to special needs planning, there's really a lot of buzzwords out there, and certainly guardianship and supported decision making are one of many that we hear over and over again. And there's so many topics when it comes to special needs planning that, I mean, honestly, we could sit here all day talking about it. So we really narrowed this down today to really focus on guardianship, supported decision making, and the things that kind of go around with that. But I just wanted to share for a moment, there seems to be a lot of confusion in the special needs planning community of what do I need and who do I need? Who are these people? And why do I need both? And so I just wanted to kind of explain that just for a minute. That when it comes to special needs planning, there's really two true professionals that you need when it comes to special needs planning. You have the special needs financial planner and you have the special needs planning attorney, okay? So they're two very different things. So there's a lot of attorneys out there, there are a lot of financial planners out there, but they're very much not nuanced in special needs. And because it is so critically important that we protect our benefits and future benefits eligibility, it's really important that you're working with a professional that understands how to protect these things. And the average financial planner and the average attorney that isn't focused on special needs can accidentally really mess you up. So we just want to explain that. And I've always kind of joked with Boyd and said, okay, I'm the money and he's the paper. So we got to have the legal documents and we got to have these things in place. But we have to have both. Okay. So I'm getting ready to just turn everything over to Boyd and he's going to take everything away. Your lines are muted today, so that way everybody can hear and kind of get a lot out of this. But we want this to be interactive. So as we're going through the slides today, if you have questions or comments, please put that in the chat box, and then I'm going to be monitoring the chat box and we're going to be addressing your questions as we go along. So thanks so much for being here. Boyd, I'm going to turn it over to you.
Okay. Let's do the next slide. Good morning, everyone. Thank you for taking your morning out to listen to our presentation. I hope it will help you. We're going to talk about guardianship and some of the alternatives to guardianship with major emphasis on the decision-making agreement. Next slide. Unfortunately, I have to give you a disclaimer. This presentation does not set up a attorney-client relationship, and there's no legal advice being given. I'm giving you a lot of hopefully good information, and just be aware that each individual's situation can be done differently. So I may be giving you some information today, and please take it with a grain of salt, as they say, because each person's situation, as I mentioned, is different. And so each part of this can be done in different ways for the person. What we're going to be doing is I've got a special needs toolkit, which I talk about, and we're going to be talking about the left-hand side of that toolkit on guardianships and the alternatives to guardianships. Next, please. Okay, the special needs toolkit is made up of a lot of different people, and all you should have your team, as Allison has mentioned, have your financial planner, your attorney, your tax person, your person that's been helping your child, other family members and other people that will help you go forward and have been in the same boat that you are. Just to give you a little background about myself, I'm a solo practitioner in the Katy, Fulshear area. I've got my wife and I have a wonderful 26-year-old daughter who we have guardianship of. And so I've been in the same situation many of you have. So that's why I enjoy what I'm doing, because I've been in the same shoes and have hit the same bumps in the roads as our kids get older. But what we'll talk about today in detail will be, as I mentioned, the guardianships and the alternatives to guardianships. Next. Okay, why do you need guardianship? Well, unfortunately in Texas, when our children turn 18, they're in the legal world an adult. And so at that point, we cannot do the same things that we were doing for our children prior to them turning 18. And guardianship and alternatives to guardianship are ways to help our children that may not be ready to become adults since they have special needs or maybe disabled. And that's what all of this is about today. Next slide. I use this is a analysis that was put out by the American Bar Association, and it's very good. And I use this a lot in my practice. And basically, when a client or potential client comes in my office and tells me, well, we need guardianship, I basically presume that they don't need it. And we start going through the various reasons why they may have it. We see if there's any alternatives to guardianship, and we'll go over that later in the talk, that maybe can keep them from going through guardianship. I know with my daughter, my wife and I, when we knew that she would have guardianship once she turned 18, but it's a very emotional time. We were prepared, but then once we got nearing that 18th birthday and going through the attorneys and the attorney ad litem's in court and all, it was almost like someone hit us with a brick. We thought we were prepared, but we were not. So I can sympathize with all of you if you have children that are maybe approaching 18 or maybe have already reached the age of 18, because it is a time that you need support from a lot of different segments, because it's a very difficult decision. But what I try to tell everyone is that we're looking after our children, how to protect them if they're maybe not quite ready from a developmental or mental standpoint to go out into the world. So that's why we really look seriously on guardianship. Next slide. Okay, in 2015, the guardianship really changed in Texas. They started going back and looking at the guardianships that have been done in the past. A lot of different things had happened, and they were not looking after what we call the proposed ward, which is a terrible name, which is what they call your child prior to the guardianship process. But in 2015, they made some major decisions. They set up alternatives to guardianship, which are now in the Texas Code, and also set up separately in the Texas Code a document called the Supported Decision-Making Agreement. And this really changed. I think from a legal standpoint, it didn't, because we always looked at this, but from the parent standpoint, the Supported Decision-Making Agreement was very good for everyone. Next slide. Okay, guardianship in Texas, there's 4 different types. There's guardianship of the person. That's what we have with my daughter. Guardianship of a person just deals with looking after the individual, and the individual does not have any assets to speak of. And they can be full or limited. We have full on my daughter. Full takes away quite a few of, in fact, all the things and all the abilities or rights of the child that's put in the code. And then limited, you can pick and choose. Guardianship of the estate is really dealing with elderly people that may have a house and bank accounts and all of that. And again, that can be full or limited. Now, the guardianship of the state also comes in when, just say, a parent dies and they may leave their minor child a life insurance policy. Unfortunately, in Texas, if you're under the age of 18, then that particular child cannot own that life insurance policy, and it cannot be distributed to them. It has to be distributed to an adult. Unfortunately, the courts in Texas and many of the life insurance companies require the parent, who is the guardian of the underage child, to get guardianship of the estate in order for the life insurance policy to be distributed. So, I tell a lot of, try to educate a lot of parents is that if you've got a life insurance policy or a retirement fund, and you have a disabled child or a child that's a minor, just be aware that unless you leave that to a particular trust for the child, then they won't be able to get that money unless you get guardianship, or that you can put that into a UTMA account, which is a minor account, which is set up in Texas, or you can wait till the child reaches the age of 18. But in a lot of situations, that could be a lot of money. And the reason that you want it into a trust is so you can distribute that money over a length of time. I was a pretty good kid growing up, but I would not have wanted $250,000 at age 18. You can also have guardianship of the person in the state, and temporary guardianship. That may be where you have an adult that could be in the hospital and incapacitated, or maybe even have when both parents die or something, and you appoint a guardian in your will, and that guardian lives out of the country, and we might have to set up a temporary guardianship until that person comes into the States. Next slide. Okay, full versus partial. What does that mean? Also want to let you know that guardianship is not permanent. I had the fortunate to sit in on the court a couple of years ago. We had a lot of the court judges in Harris and Fort Pender County were voted out. So we had a huge influx of new judges, and I was sitting in on one in Harris County, and a young man was getting his guardianship given back to him. He was nonverbal, used the machine to talk, and he actually was talking to me while we were sitting outside the courtroom. I thought that was pretty interesting. But he had gone to HCC and got his computer degree, and he was getting his guardianship given back. I mean, it was rather a teary deal in the court, and that was very interesting to see that. And I always like to tell parents that. So, if you get to your point where your child is 18 and you're not sure whether they need guardianship or not, and it can be partial. We can give them a lot of the rights back, or give them some. And of course, I've got them noted in the slide. Those are the major ones that you can take away. But, think about that as you reach that particular point where the guardianship may come up, that, you can, take away the right to pick your residence, or do financial or do managerial decisions. And if they're not mature enough to do that yet, guardianship may be the way to go about it. And as they mature or learn to deal with their guardianships in a more productive way, then later down the road, you can give guardianship back to them. Of course, you still have to go back to court for that. Next slide.
And Boyd, we see this a lot, especially if we have severe ADHD or high functioning autism. We're definitely seeing this a lot, where the child, the parents are still very hopeful and optimistic. The child is smart. There's a lot of things going, but from a maturity level, they may be anywhere from 3 to 5 years less mature than their peers.
Mhm.
So it ends up being kind of an interim thing that, as they grow and mature, this is just something that we definitely see very commonly.
Yeah, one of the things with that, and we'll talk about it here shortly, is the supported decision-making agreement. And that's one of those that is kind of in the gray area. If the child really doesn't need guardianship, or maybe needs it for 4 or 5 years, you can get that decision-making agreement, and we'll go over that, of course. And then the other thing, if they're not able to sign a power of attorney or medical power of attorney at that time, then that's the real clincher, is guardianship may be needed. Uh, Guardianship of the person, really what that is whatever you were doing for your child before they turned 18, is what guardianship of the person does. Uh, it provides everything that you're doing prior to that. Now, what guardianship does not do is that once your child turns 18 and they may commit a crime, then the child still has to come up with that, serve whatever is going on with that crime. That doesn't keep them from going in court with that. Of course, if they're incapacitated at the time, that will help them with ever. Also, a parent cannot force a child not to go see someone. As long as that person is not an endangerment to the child, and if they would actually unfortunately run off and live with someone, then the parent or the guardian cannot call the police and say, please go get my child back because I have guardianship. The only way to take care of that is if the child is in danger. So guardianship is looking after the person, but it's not looking after the actions or the inner workings of a young person. Also, unfortunately, if your child may be having sex or run off with something like that, you can't stop that either unless it's an endangerment. And then down also in Texas with everything from a sterilization standpoint, you actually have to get a court order in order to do that if you've got that comes into the picture. But other than that, guardianship is really of the person is just looking after your child the way you have been. Next slide. Guardianship of the state, again, in most cases, it's for the elderly. I had a question the other day, well, why don't we just do guardianship of the person in the state all the time? Well, the problem with guardianship of the state is that you've got to have a financial bond for the amount of the estate. In most cases, in my situation, most cases with these kids turning 18, they don't have an estate, so there's really no need. And then there's also, you've got to do inventories, investment plans. So, it's really a very complicated process. So if you don't have to do guardianship of the estate, then we normally never do it with that. Also, as I mentioned before, if you're in that situation where you may have a spouse that has died and left the minor child, or even the child with a disability with a life insurance policy or retirement fund, then unfortunately, you're probably going to have to go through guardianship of the state with that. I've actually got 2 cases right now that we're dealing with that. So it's more prevalent than you think it is. Next slide. Guardianship steps. Well, I usually tell everyone 8 months prior to the 18th birthday is when you really need to start thinking about guardianship and getting with an attorney to go forward with that. Reason I say 8 months is that you've got to have a physician certificate signed, and we'll go over that here shortly, on the child. And basically that physician certificate gives how it has a lot of check boxes, and basically what it does, it lets the physician go over and tell the court how the disability affects the day-to-day activity of your child. I tell a lot of moms and dads is that if they're on the border on whether their child needs guardianship or not, take that physician certificate and fill it out yourself. And that will give you an idea about what's really happening with your child, and whether in fact they probably may or may not need guardianship, and the attorney can do it. And also with that, we have a box in, I believe, page 3 of that, and it has about the IQ. And a lot of times we have those tests done by other people, psychiatrists and things of that nature, and our physician doesn't know that. So we actually there's a place there where if you have intellectual disability, we can put that in the form, and the doctor can use the other report in order to do that. Again, as you see here, the physician's certificate can be signed within 120 days of filing the guardianship petition. One thing we do know is that I had to tell a lot of clients is that you can't have the evaluation done 6 months ago and then have the physician certificate signed using that evaluation. The evaluation and the signature on the form needs to be at the same time. And then once you hit 180 days prior to the 18th birthday, we can file it with the court. What will happen in Harris County, I do surrounding counties also, it's a statutory probate court, and they will have an investigator from the court come out and ask you and the ward, your child, I'm so used to saying ward, terrible name, of different questions, and file a report with the court. The main thing that's the most shocker with all of this is that you're going to have a constable knock on your door and serve your child with a petition. And of course, in a lot of our situations, our children wouldn't know what that is to start with. But I was not home when my daughter was served, but my wife said that was kind of a strange situation when the constable was knocking on your door. The other things that have taken place since I became a guardian, you have to take an online course, about a 45-minute course, and I actually took that myself. I didn't have to because I was grandfathered, but I thought it was kind of hard to tell my clients they have to take one when I didn't know what was going on. And thank goodness I did pass. And you have to have a certificate that you send to your attorney, and he files it with that. And also, I've got a number of clients whose children live in group homes. We have to have the name of the administrator in the group home, and any adult siblings that your child that you're getting guardianship of, we have to serve them with a waiver, along with if they're in a group home, to serve the group home administrator waiver. Next slide.
But wait, I've got two questions. One question is, what about the unfortunate circumstance of divorce and parents of disagreeing on whether or not guardianship is needed or not? What is there a workaround for that? How does that work?
Yeah, basically what happens with that is that one parent can file for guardianship even though the divorced parent does not feel that that's the way to go. And then we just basically go to court as to be a contested guardianship, and we prove to the judge that the child needs guardianship. The judges in Harrison, Fort Bend County, even Montgomery and Waller County are fantastic. They really look after what the judges do, look after the best benefit of the child. And so, you know, if you've got a good story to tell the judge, he really looks at it, and that's how we go about doing that. Now, if you've got two biological parents that are divorced and one is remarried, and you have a step parent, if the biological parent waives their right to be co-guardian, then the biological parent and step parent can be guardians. And also, if you've got a divorce situations where you can't find the other biological parent, then all we would do is have the court serve the last known address, and then you can get guardianship of your child that way. So
Okay.
there's a lot of workarounds.
So that was my other question, was about the joint, the co-guardian or joint guardianship. We get a lot of questions on that, on whether or not that's a possibility and how that works.
Yeah, the co-guardians can only be biological parents or step parent that has the waiver from the other biological parent. And when you've got two divorced parents that have co-guardianship, it's interesting. If it's after the divorce, then in most cases, once the child turns 18, they just need to work it out between each other. If you're getting guardianship during the divorce, then that's probably where you need to have in the divorce decree visitations and things of that nature. Uh, One thing to note, since we're talking about divorce, is that in a normal situation, and there's Texas code where you have guardian, you have visitations and things of that nature. Uh, with a special needs child, especially one that may be really disabled, then taking that child out of one environment and putting into another environment can be very stressful. So, a lot of these divorce with the family law attorneys, they really need to have a consulting special needs attorney so they can at least bring up those situations, because it's a lot different with that. Um, okay, what else?
We have one other question. I think you hit on it, but I just want to be sure. What about the case of divorced parents when one parent is not involved and lives out of the country?
Hmm. Well, in that case, then we're, you're not going to give a guardianship to someone outside the country. So it would be the parent that's inside the country at this point. Mhm.
Okay, thank you.
Okay, I wanted to put this in. I know you can't hardly read it, but this just gives an example of what the physician certificate that I was talking to about. Uh, and it has the evaluations of the proposed ward physical and mental functioning, which the doctor can do that. But the main thing is the second part on the right hand side. It has the cognitive defects, short-term, long-term memory, immediate recall, ability to make responsible decisions. It has stuff like complex business, medications, and being able to do your daily living things, and then development disability and things of that nature. But this is really a fantastic document that really helps the court understand why the child needs to be under guardianship, or either the adult that may need to be under guardianship. And again, extremely helpful for the parents to, if they're on the borderline on whether we need or not, is go in and check it off yourself. Because at the end of the day, the parents know best about their child. I know my wife has been in doctor, and she's here, Carrie Handley, but uh, I know she's been with many doctors, and they kind of look at her strange when she says, "Have you tried this or tried that?" And then we had a recent deal with my daughter where she had to have operation on her sinuses, and uh, Carrie asked the doctor, "Well, can you do a sinus scan?" And he kind of looked at her, and lo and behold, we did a sinus scan, and it was really bad in her sinuses. And then, of course, after the operation and all of that, the doctor said, "Well, Miss Hanley, you're right. I thought you were crazy at the time, but you're right." So what I'm trying to get at is, we as parents know our children. So never, never not talk to a physician or talk to a healthcare worker about your child because you think they know more than you, because they don't. And so anyway, I just I always like to give parents, what we've gone through, and, don't ever back down for your child. Always fight for them and go forward with them. Next slide. Okay, who can qualify to be a guardian? Well, as I mentioned before, the child's parents, uh, and then a step parent under certain conditions can be a guardian. Of course, family members and grandparents. And there are some qualifications to be a guardian. You have to be over 18. You can have a criminal history. Now, you can have. I've got one client that we've had a criminal history probably 25 years ago, and we'll have to go in front of the judge in the guardianship process and explain to the judge what went wrong 25 years ago. It was when the person was very young. It was not a violent criminal issue. I think if you had violence in it, then that really just totally disqualifies for you. But if you do have a criminal history, we can go back and try to talk to the judge and get that. And then of course you have to have a capacity, and you can't be indebted to the ward. Excuse me. That means you can't owe them money. A lot of that has to do with elderly people and things of that nature. But mostly common sense on who can be qualified. Now, what takes place, I also tell my parents is if you have a child with special needs, even if they're below the age of 18 or as they get over 18, you get guardianship, be sure to have it in your will who the successor guardians will be. Because what happens if you die without a will or do not name a guardian in the will, then unfortunately Texas is going to do what they do. And according to the code, they're going, if you don't have it in your will, and if you have it in your will, what we would do is go to probate court with your will, with your death certificate, and approach the judge and ask them to name the person guardian who you'd done in your will. I've done one of those in Montgomery County, and it was very simple, and the judges agreed with who the parent asked for. But if you don't have a will, they're going to go with grandparents first. I've had some great grandparents. All those are my parents, of course, are gone now. But you know, one side of the family may be better than the other, so it's better to name those. And then after that, they go with family members, and then go down the line. So you know your child, and you probably know your relatives and who could actually look after your child better in the event that you're gone. And you can also pick a friend instead of a loved one or a family member. Next slide. There we go. Okay, there's alternatives to guardianship. I mentioned in 2015, the legislator made it a law that we have to look through all of these. Of course, we did it beforehand. Now it's a law that we have to look at all of these different restrictive alternatives before we go forward with guardianship. And we actually have to tell the court when we do that, that we did look through all of them. And again, in the court, which I think I forgot before, is that when we do go through guardianship, they're going to appoint what we call an attorney ad litem to look after your child's interest in court. I've got an interesting story. When my daughter, we were getting guardianship, we had this lady, I won't call her name, but as the attorney ad litem for my daughter. And then she came back and did all my wills and trust at one point. And now she's a mentor to me. So I may be an old guy, but I've only been practicing since 2015. I was a geologist for 40 years, but now I'm doing something that I totally love to do and enjoy helping people. And, you know, since I've been and walked in the same shoes as a lot of y'all, then that really helps me in my practice. But anyway, she's helped me a lot, and we did that. Some of the things in the least alternatives or the durable power of attorney and medical power of attorney and HIPAA release. HIPAA release is actually the ability to get medical records on your loved one. The problem with the first two is that the child, once they turn 18, needs to have the capacity to understand the legal ease or the legal writings of the power of attorney and medical power of attorney. I've done a few of these for children once they turn 18 with disabilities, but the problem is that I really have to be convinced. Normally what I do is get these children in a room away from their parents and ask them explain the documents to them and ask them, because if their parents in the room, they're going to look to the left and look to the right and say, Mom, do I need to say yes or no? So I really do a very detailed analysis with the children if I do those for them. And then the HIP release, of course. Now, the good thing about the medical power of attorney and all of that is that they will allow you to get into the hospital. My wife had a situation a couple of weeks ago. My mother-in-law was in an accident and, of course, was taken to the hospital. Of course, now we can't even go into hospitals with our loved ones, but she was able to fax the medical power of attorney to the doctor and at least talk to the doctor outside in her car in the parking lot and check on her mom. So those are very needed. If you've got a child going out to college, be sure you have power of attorney or at least medical power of attorney on this, because if they're in an accident at college or something, then you can't call up and find out about them, because the once they become adults, then the confidentiality kicks in, and it's very hard to get information on loved ones unless you have that. Um, won't go through all of those, but we're going to jump to the supported decision-making agreements, which are it's a document that's very beneficial to everyone. Now, did want to say something. If you've got elder parents that are still driving, there's something called Kate's Law that you can get the uh, highway patrol guys to give them a retest, and they won't tell them that you're retesting it. So if you've got parents that you don't want to take the keys away from them and be the bad person, then that's something that you can do. Sorry, I'll go to the next slide.
We have a question, and it was
Okay.
back to something that we were talking about a minute ago. And I think it keeps kind of going around these broken relationships or divorce or whatever. So if a parent is still in the country but doesn't even have any relationship with the child, um, can the what about if the step parent's willing to accept full guardianship, and then it was said that the biological parent must sign a waiver?
Yeah, yeah, they must sign a waiver. Normally what happens, if what we'll do is send them a waiver by certified mail. If they don't respond to that, if it's a biological parent, then wherever their last address in the United States, even overseas, we would send them have them served by a constable. And once they're served by a constable, it really doesn't make any difference whether they were actually at the address or not, but that's all the court needs to go forward with the guardianship. So that's what has to take place with that. Mm-hmm.
And then just one other thing, I can't stress enough the importance on that medical power of attorney, like we were talking about, for your non-disabled children that go off to college, and for
Mm-hmm.
your aging parents that are of sound mind right now. But you know, anything can happen. A stroke can happen. Anything can happen quick, fast, and in a hurry. And so don't, as we're so focused on our special needs families and kind of planning for our future for that, don't forget about your aging parents, because it's really, really important. And equally important, again, if you have aging parents that are out of state, or what have you. So it makes it very difficult if you're across state lines if you don't have that document. So just add that to your list as well.
Yeah, that's a good point, because you know, you can tell your parents, a lot of them don't want to give up their independence, but you know, if your parents can give you these documents, and we can have in the documents that they do not become active until the parent becomes incapacitated. So you know, you can tell them that if they're really don't want to sign anything, that, you know, I'm not going to get in your business until you actually cannot make a decision. And the only other alternatives, if they get incapacitated or start getting toward dementia, something, is to get guardianship of them. And that's just really crazy to have to do that when you can get these two documents signed with that. Okay, let's start on the supported decision-making agreements. You've probably been reading this for the past few minutes, so we won't go forward with that, but it's a process of supporting and helping your child get the information for them to make a decision. Next slide. Okay, who can enter into agreement? Well, anyone that's over the age of 18 with that. The good thing, depending on how you want to look at it, is that compared to the power of attorney and medical power of attorney, where you have to have capacity and know what you're signing, the state legislators left that a gray area on this document. They did not specify the level of capacity a person must have. So what this does is that if you're in that gray area, you don't know whether your child, or you've made that decision that your child does not need guardianship, and he or she may not be quite ready to go out into the real world and make decisions on their own, then you can have them sign this agreement, and it will allow you to accompany to go with them to meetings and explain what the person on the other side of the table is talking about. The other good thing about this is that if you can't afford a guardianship, and there's a lot of good organizations in town. We've got the uh, Bar Association that does pro bono work. You've got the disability rights group here, uh, and a lot of people, but there are people that may not make enough money to be able to afford a guardianship. And this letter helps them at that point. It will allow their child to sign something and then at least get in the front door, whether it's the hospital or something of that nature, to help them. Next slide.
Can you tell people, because this is a question that we get a lot, I know every case is a little bit different, but can you just give us a range of what a person could expect to spend on guardianship?
Uh, yeah, guardianships can run between 2,500 and 5,000. It just really depends on the law firm that's doing it. And normally normally those fees cover the filing fee and the attorney's fees. The other fee that you'll have is the attorney ad litem fee. In Harris County, the maximum that can be is 600. Normally it runs from 450 to 600. In Waller County, that fee is waived. Montgomery County, usually the maximum is 400. And unfortunately in Fort Bend County, it's wide open. I've had one the other day that, or actually about 6 months ago, where it was 1,900. And I argued with the judge that that was absurd. And that the court, my client should not pay that. And in the end of the hearing, the judge paid for it themselves. So in Fort Bend County, there is an open-end cost on the attorney ad litems, but in probably 70% of the cases, Fort Bend pays for it. In most cases, the last one I had in Fort Bend County that the client paid for was $750. And so that varies. The only other cost that the parent would have is that they have to pay a bond. In Harris County, it runs between 25 and 50. Waller County, it's does not cost out. I'm sorry, I said something in Waller County a while ago. You do have an attorney ad litem fee. It's the bond that's usually waived in Waller County. In Fort Bend County, between 25 and 50 per family on that. So the bond's not much. And then the other costs associated with guardianship or the guardianship letters that are $2 a piece. So you can add, I would just go 600 plus 50 plus 10 for the letters plus the guardianship, the attorney's fees. So that's usually what you're paying.
You told us that we can get started on guardianship 6 months prior to the child turning age 18. And I know this is the weirdest year ever with the pandemic, but in general, how long does the process take? Like if you gave us a range of months, or how long?
Yeah, I think the quickest I've done was 2 months. That was prior to the pandemic. Yeah, actually, the pandemic has helped us. We're doing everything by Zoom. And even the court hearings are done by Zoom. And most of the attorney ad litems are meeting by Zoom. I know that in Harris County, where we have a court investigator, they're even doing some by phone calls. So it's changed that tremendously. And then with the hearings by Zoom, the other day I had a father that was walking in a field up in northern Michigan, and we were doing the guardianship hearing from that, with him on his iPhone. So that's really helped out. The only setback that I have been associated with is that getting the guardianship letters after the hearing. That's usually taken about a month, where before you could have gotten them in 2 or 3 days. So that's really the only setback, and really plan for about 2 months at the quickest that you can get one done. The reason we can file 180 days prior to that, that way probably a month before they turn 18, we'll get a hearing set up, and then we just sit back and wait until they turn 18. So that's why it's always good to file as soon as you can. and that way you can get everything in at a leisurely pace. And then once everything's done, we can just sit back and wait for the 18th birthday to come up.
We got two quick questions.
Okay.
Does a simple explanation of the legal aspects of durable power of attorney and medical power of attorney exist? Something I might review with, is it something that I might review with my child prior to this meeting? Is something that they could look at or review?
Yeah, I would Google that online. You have I've actually got on my blog on my website some information on it. You can get the power of attorney is a statutory power of attorney in Texas. What that means is that the court has set up the language that they would like. A lot of our language we add to it, but so they can actually go online and download a one to go over their children with. Same thing with the medical power of attorney. I also tell my clients, be sure it's better to use an attorney to do those, because if you try to draw up one yourself, if you leave out some language, it may hurt you at the end of the day. So it's better to, even though you can download those forms, it's better to have an attorney draw up one for you, so everything's done correctly.
Boyd, I'm a stickler on that. I see a lot of do-it-yourself, the DIY wills and other documents and stuff like that, and most of them are wrong. I mean, most of them I'm sending referrals out to get reviewed. The thing is a simple will or some of these simple things, surely you can do online. But by virtue that you're here and that you have a special needs child, your life isn't simple. It hasn't been simple. It continues not to be simple. Things every law conference, um, and that actually happens every year. I'm really a huge proponent of a professional doing this work for you. And somebody is not on mute.
You're breaking up on Allison.
I'm sorry.
It's okay. All right, next slide. Let's see where we are here. Someone needs to mute their line. We've got some knocking in the background. All right, next slide. Okay, supported decision-making agreements. How does this agreement allow you? What I want to let you know, it's assisting your child or your young adult. Assist, assist, assist. You cannot make any decisions for them. It will allow you to get into a room. I know you're going to make decisions for them, but it will allow you to get into a room and explain to them what the individual on the other side of the desk is telling them. And because you know how to, in these situations where our childs have special needs, you know how to talk to them and how they understand things. So this allows you to tell them what's going on, why they're signing a particular agreement, or why they're buying, what they're buying a car with, or how that's going to affect them. And then at the end of the day, they have to make the decision. So just realize that that this will allow you to get into a room or to a meeting with your child, but it doesn't allow you to make decisions for them. That's why I think a parent really needs to understand when they're having one of these signed by their child, whether you're looking after them in their best interest. If they understand what they're signing, then that's great. But a lot of these are done where the parent maybe doesn't want to go through guardianship. The child doesn't have the capacity to sign a power of attorney, a medical power of attorney. So just be aware and how you're helping your child when you use one of these. Next slide. Okay. Let's give a recap. What have we talked about today? Go back, please. Your child, your child turns 18. Next slide. There we go. When your child turns 18, he or she is an adult in Texas, everything changes. Confidentiality comes in, and whatever you were doing prior to the child turning 18, you cannot do it after they turn 18 legally, unless you have a power of attorney, medical power of attorney, or guardianship, or the supported decision-making agreements. We mentioned briefly with your parents, be sure you have power of attorney, medical power of attorney, because you don't want to go through the process of getting guardianship if they become incapacitated. And in most times, our parents have each other as power of attorney and medical power of attorney. And I was lucky with my parents. We both had them on there, both had me on there. So I was able to take care of them when they got to a point where they went into a nursing home. We don't have anything on this, but what I also wanted, we have a few more minutes. What I wanted also to say is that be sure you have in your wills who's the guardian of your child, especially if they're minors. Have that in there. On your retirement funds, your life insurance policy, and all of that, just realize that a child cannot inherit that as a minor. If you do, just have some notations in there on how to go about that. A lot better if you have a contingent testamentary trust in your will, which will say that if your minor child, if your minor child gets an inheritance, it will go into that trust. And also have it's a whole new subject, special needs trust, but be sure at least to have a testamentary special needs trust in your will. Testamentary means that that will stays dormant until your death, and they probate your will in probate court.
Wait, I got to chime in here. This is
Uh-huh.
a and some of you guys have been on some of our Zooms before, where we've totally dedicated it to SSI and maintaining eligibility and things like that. And I can say that if we have a Zoom meeting and there are 2 people on it, at least one person has their minor child, special needs child, named as a contingent beneficiary on something that they have. So what we see is this is how it works. When it comes to life insurance or 401ks, 403bs, whatever, that if you're married, you have your spouse as the beneficiary. And then if your spouse is dead and gone, then you have your children. I mean, who else? You list your children as the contingent beneficiary. And so to Boyd's point, in this example, the smart way to do this is to have a testamentary trust for the benefit of the non-special needs child. And then that way you can spell out how the child's going to get the money and when, right? Opposed to them, if you just leave it straight out to the child, when they're 18, they're going to get all of the money. It's a bad idea. Even though your kids are geniuses, it's a bad idea. So, and then the other side of it is, and we've seen some major issues, big issues where a parent died and they left the special needs child the money in their name outright. And so basically what happened is, again, it sat in trust until the child turned 18, and then they got all of the money. And so they immediately disqualified themselves for SSI and Medicaid, which is a big deal.
Yeah.
How we accomplish this is, instead of leaving it to the child directly, this would go to the third-party special needs trust for the benefit of said special needs child. So you can still have the money for the child, but it goes into a trust that won't be looked at in the eyes of Social Security. So this is a whole nother topic, and we have a lot of Zoom meetings on this. But because it's such a big deal, we want to say it. And people don't understand. A lot of people don't understand, because you've gone this many years and your child never qualified for any benefits through the state. No SSI, no SSDI. They qualified for nothing. But what happens is, when they turn 18, it's magically based off of their assets, not yours. Even though they still live in your house and you claim them on your taxes, it's based off of their assets. So because they have no assets, then all of a sudden, after 18 years, they now qualify for SSI. So, so that's why it's so important to have these conversations now and kind of look at these things, to make sure that you really have the money in the right buckets to preserve their eligibility in the future if they're not qualifying for anything right now. So I'm so glad you brought that up, Boyd.
Yeah, the other thing I like to mention is that we had a situation about 2 years ago where a father died unexpectedly and left his child with special needs everything, and even the house and things of that nature. And so he was actually getting SSI, and the mother was in dilemma on what to do. What will take place is that while the will is still in probate court, we can go in and petition the court to do a trust within the probate court. They're normally called 1301 management trust. And then within that management trust, making a special needs trust. And then everything can go into that trust before it comes out of probate. Now, the only issue with that is that the court will probably not allow the other parent to be trustee. The court will either appoint themselves trustees, or if it's um, a big estate, then they're going to have a bank being the trustee. So, if a parent had put in the testamentary trust prior to that, then you wouldn't have that done, and then you would have control yourself as a trustee or whoever you appointed a trustee. So, there's ways to fix things, but then if you don't do it right to start with, you lose control, whether it's in the courts, being court's treasurer, or have the court has appointed a bank to look after your kid's money or your kid's estate now. So, if you plan a little bit now, it will save you money in the future, and then you can also keep your assets under your control too. So.
We have just a couple of quick questions, and we're gonna wrap up. Is as far as guardianship is concerned, it takes place in whatever county that the child lives in. Is that correct? You can't just go to whatever county you want,
That's
right?
correct. I had one the other day where the child was in a group home in Fort Bend County. The parents lived in Harris County, but we filed in where the child lives. In our situation, we lived 18 years in Harris County and moved 2 miles across the county line in Fort Bend County a couple of years ago. And we had to transfer our guardianship from Harris to Fort Bend County. Uh, Nowadays, that costs $400 or $500. When we did it, it was actually free. So that's even changed. But it's every year the guardian has to submit a report to the court. My wife does that for us. And then so you may be able to get by one year if you move to another county, but eventually you will need to transfer your guardianship to the county you live in. The reason behind that is that the court has the legal authority to look after your child, to keep up with your child and be sure that the guardian is doing their job. Normally, they are supposed to check up on you every year. Of course, we've had my daughter's 26, and they've never checked with us since age 18, but they'll probably start it once they hear this. But you know, it's on. Your child is still under the court order, and the courts are supposed to be sure that you're looking after your child or your young adult or your aging aged person. So.
Okay, two more. Okay, so we mentioned earlier that we strongly suggest, so can you do supported decision making yourself is one question. And I know we said we strongly suggest professional
Yeah,
help.
the Arc of Texas or Arc of Katy, they have great supported decision making agreements that you can download. I normally don't give those out with my clients. I just actually send them one of those if they want it. But it is in the code. I guess I could do one and draw up one and charge for one, but all these organizations have very good ones. So that's the one that I normally give out.
Okay, and then we have when you have guardianship of your child, will they be able to build their credit or is that taken away? That's a great question.
Good question. Normally, if you have the guardianship over the financial matters and the business matters of your child, no, because everything. you can probably still put in their name, but then they won't be able to sign for it anyway. So you may be able to do things under their social security number and under their name, and possibly they can do it, but at the end of the day, they won't be able to sign anything.
Okay. Yeah, thank you for asking that question. That was a really great one. We haven't had that question before. Would supported making be applicable for my 52-year-old son who is mentally ill? And would an attorney be required to obtain that?
What was the first part of that question?
Basically, if we have a child that is clearly not a child, 52 years old, that is mentally ill, okay,
Mhm.
would supported decision making be warranted for someone in that capacity, or would that be healthcare power of attorney or power of attorney? What would that be?
Uh, well, if he has the capacity to sign a power of attorney, medical power of attorney, a lot of times they can have mental issues and still have a very good capacity. So I would probably, well, either three. You can have supported decision making agreements that doesn't talk about capacity, or if they do have capacity to know what they're signing, then definitely get the medical power of attorney and power of attorney done with them. I've recently I'm an attorney ad litem on a guardianship case in Texas, in Harris County, where the gentleman is 55 years old and has mental issues, uh, and his parents are just getting too old to look after him. And so they've requested that the county take over as guardian of him. And so we're doing that. So it can go, whether they're just turning 18 or 52 or adults, your parents are aging. It can be in different situations.
Boyd, we just want to thank you for being here with us today and joining us and providing us this great information. Our contact information is on the screen, and we have recorded this presentation, and we will send the slides and presentation out to you, out to those who registered on Monday. So for those that missed it, they'll get it, and you guys will have a copy of this as well. But we'd just like to thank you all for being here, and you guys can look out for some other webinars that we'll put out. We're really, really focused on putting educational information in your hands, so that way you guys are, actually just instead of working from behind or kind of, putting out fires of things that didn't happen, that you're ahead of the game, and we want to help you with that. So thanks so much again for being here, and thank you, Boyd, and
Thank you.
and thank you, Kat. We're pleased to share this information with you, and I hope you guys all have a wonderful Saturday.
Take care.
Here.